Okay, welcome. Thanks very much for joining us again. This is our second Desert Island Discs type video. Of course, we pay all due homage to that format. We're not stealing it. This isn't plagiarism. This is our own special Liverpool version. Last time we spoke to Professor Warren Barr. Now I'm joined by the head of the school, who is, of course, Professor Debra Morris. So I'm going to talk to Debra in a similar way, with a similar format. So we'll have a brief introductory biography, then we'll move into 4 areas that have spiked her interest generally in relation to equity. So Debra, would you be able to tell us please how you first got into equity or legal academia generally, please?
Okay, well, when I was an undergraduate student, I think I was quite taken by this subject, and I was particularly interested in the charity part of the course. And it's amazing because all these many, many years later, it has still stayed with me as my most interesting area for research and the area in which I have become an expert. So after I'd completed my law degree at this university, I undertook a master's degree by research, and at that point you'll appreciate that after 3 years of studying as an undergraduate, you're not really sure what you might want to study further, what might pique your interest. But I had studied tax law as an undergraduate, and I'd been quite interested in that as well, or bits of it. And I'd been interested in my charities module within the Equity and Trusts course. Charities part of the Equity and Trust course, and my tutor at the time suggested, why don't you look at the tax implications that as they particularly relate to charities, because one of the things that you'll learn when you look at charities is that one of the reasons why it's such a big deal to ascertain whether a purpose is a charitable purpose or not is because a trust that's set up for charitable purposes enjoys a significant number of tax advantages, both for the entity itself and also for those who give money to the entity. So that was quite interesting, and at the time, and I won't reveal the date because that will say a lot about how old I am, there was quite a lot of changes going on, and there was this notion at the time that giving more tax reliefs to charitable donors would increase the amount of money that was given to charities. So there were a number of new tax reliefs that were being considered at the time. So I spent a year researching in that area and writing my thesis. And then I was very fortunate, as soon as I got a job, I started teaching equity and trust straight away. For a very brief period of time, I also taught public international law, because I was able to move away from that quite quickly and got into my areas, equity and trust, land law, and a few other bits and pieces. So I've been teaching equity and trust a long time, and I've never really regretted that decision. I've always enjoyed it. My interest in charities has probably moved away from the trust aspects, but it's always there at the core.
Yeah. Okay, just this might give away an age thing. I don't mean to, of course, one should never ask a lady her age and so on. But just because this came up a bit in Warren's interview, where we were talking about the lineage at Liverpool of what he suggested with Maitland, who taught here as a visiting lecturer in 1883. Not the 19th century, definitely not that. In 1883 or 1884, not that. But then Professor Parker of Parker and Mellows.
Correct. So when I was a student here, Professor Parker, David Parker, taught me, and he was actually my tutor, so he did my lectures, and he would sit there with his faded manuscript of his book and just reading from it. The students had the actual textbook on the table and were just following. We didn't have to make any notes. And then I was in his tutor group as well. So yes, and it was not long after I became a lecturer that he sadly passed away. So we have a pretty good lineage at this university.
We were talking again in this kind of continuum, Maitland, Parker. Well, and it's straight into Morris then, isn't it? Because of being taught by him, which is brilliant. So, and then Morris into our undergrad. So when Oakley took over, just this is because we addressed this on the previous video. When Oakley took over Parker and Mellows, because of that Liverpool link and your link, was there ever a discussion, particularly when Oakley then passed away, that you might take over Parker and Mellows?
No, by that time I was very much sort of into the charities. So, for example, the main book on charity, the main text on charity, which is Tudor on charities.
Yeah.
It's in, I think it's in its 9th, or now it's in its 10th edition.
Yeah.
But myself and someone who used to teach here, Professor Jean Warburton, we took on the editorship of Tudor on charities.
Yeah. Okay.
And then, in fact, I also got involved with Picarda, the
Yeah.
law and practice relating to charities as well.
Yeah.
So I had my hands full, really. So I hadn't broadened out into that whole area.
But with because obviously you've got very onerous administrative functions.
Now.
Absolutely. With that added to your editorial work, how frequently, for example, are those texts updated? So how often do you have to submit?
Well, there was a time when we had a bit of a rush on, and then there was a time when it goes slow again. So sometimes it depends on the publishers and how they change their. One thing about publishers, you appreciate this yourself, that the people that you're dealing with and the editorial team are always changing. And you, at one point you're told, like, we're wanting a new edition quite quickly, and then it changes again. But there was so with Picarda, there was the 2006 Charities Act, which you'll remember changed a significant amount of things. It was the first time we had a statutory definition of charity, as an example. So there was a lot of activity around then. And then there was a codification of that act and various preceding acts in 2011. So there's been an update to Picarda, but Tudor has moved to being edited now by some practitioners. It's no longer within the... Yes.
Or reflecting your workloads. On that, your sort of connection with Liverpool, just on the bio bit for a bit longer, you have spent some time in the Cayman as well, haven't you?
Yes. So basically I came here as a student many years ago, and apart from 9 years in the Cayman Islands, I've been here all the time since. For those of you who don't know, the University of Liverpool has an affiliated law school in the Cayman Islands. It's very, very small, and in 2001 I went out there to teach on a 1 year, stroke 2 year, possibly 3 year contract, but we stayed for 9 years. After 9 years, we'd exhausted the tiny island, which is, I don't know, less than 20 miles long by about 5 miles wide. Not great when there's a Category 4 hurricane coming at you, but other than that, it's fantastic. But then an opportunity arose for me to come back here. So Jean Warburton, who I mentioned already, she was retiring from here, and it left open quite a sort of a nice position for me to take on the charity law leadership again, which I'd had before I left.
So is that when your chair was, you were given your ad hominem chair then, when you came back from the Cayman?
No, I came back as a reader, and a couple of years later I was promoted to the chair. Yes. So, and then a couple of years after that, as you've already suggested, I became head of school, so less involved in the teaching, but really delighted to be having this involvement with the students now.
We'll hopefully do some supplementary videos to, particularly with obviously with charities with Dr. Picton in the second semester.
Yes.
Excellent. So that's some biographical background. Now what we'll do is descend into the see how many areas we can do in our limited time. We're keeping these videos nice and snappy, so I'd like to ask you for perhaps 3/4 areas of equity or charity law, or anything really that you're interested in our area, that can be secondary sources, case law, statute, anything really that's just of interest to you. So what would be your first?
I think the first thing I'd mention, and I've always found this very inspiring, and it's something that I've read out before to students, it's from the David Hayton's little book, The Law of Trusts. I'm not sure if this is the latest edition, it probably isn't, but I'm sure it's the same. You'll see, you'll like that, it's got a signature in it. Best wishes, David Hayton.
Excellent. Yeah, we do have a excellent. I was going to say there's a link with Caribbean islands and
indeed.
Trust people.
David Hayton, well, he was at King's College, but then he became a judge of the Supreme Court of the Caribbean?
I'm not sure what level he's at now, but certainly.
Okay, so and he visited the Cayman Islands when I was there. I think that's when I got him to sign this. So he came to the law school. The great thing about being on a very small island is that if anything happens, you can be right in there involved. So he came to the law school. He gave a lecture for the students. I went out for dinner with him, and I imagine I brought the book along, and he signed it. But on the very first, I think it's page 1 of this book, there's a fabulous introduction to trusts, and if you don't mind, I was going to read out a little bit about this. The title is The Guardian Angel of the Anglo-Saxon. So this is about how fantastic trusts are. And trusts, as you'll appreciate, is a big part of your equity and trust course. So it starts off by saying trusts play a vital role as protected pools of ring-fenced assets in British society and in countries governed by British in earlier eras, for example, the USA, Canada, Australia, New Zealand and India. Even European and other countries which do not have the British concept of the trust in their domestic law are becoming prepared to recognise many aspects of foreign trusts as a matter of private international law when matters involving such trusts arise in their jurisdictions. Indeed, their legislation has provided protection for pools of ring-fenced assets in limited areas, for example, those involving financial services. I'll just read a little bit more. One cannot even hazard a guess at the amount of trust funds worldwide. In the UK, charitable trust funds and funds of charitable corporations have income of over 26,000 million a year, with assets exceeding 70,000 million. And the value of their tax and related benefits is over 3,000 million a year. Huge amounts are held on private trusts established by will or by deed for benevolent or paternalistic or dynastic reasons. Inland revenue figures indicate that in the UK there are over 65,000 discretionary trusts with an aggregate value of over £8,000 million. Most such trusts are of relatively small value, the really large trusts normally being offshore in places like Jersey, Bahamas and the Cayman Islands. It is commonplace for persons of ordinary means to take out a life policy to be held on trust for spouses and children. All land in England and Wales that is owned by more than one person is held on trust for the co-owners. Assets of unincorporated clubs are held on trust for club members. Trade union funds of vast amounts are held on trust. Over 8 million employees are members of occupational pension schemes, and pension fund trusts in the UK are worth over 700,000 million. And he goes on in this way. He also talks about nations even combined to set up trusts. So the United Kingdom, Australia and New Zealand in 1987 set up the Tuvalu Trust Fund of £12 million to help the inhabitants of Tuvalu, formerly the Ellice Islands, southeast of Nauru, after winding up the British Phosphate Commissioners. The winning nations of the First World War in implementing the Young Plan for German reparations, arranged in 1929 for the creation of the Bank of International Settlements to act as trustee to whom payments should be made by Germany and by whom the distribution to the appropriate recipient should be managed. So basically what he's doing there is setting up all the different kinds of uses of trusts, from really international, interstate matters to the very mundane, we're all parts of pension funds and co-owned property and that kind of thing. I think it's a really fantastic introduction. And bear in mind that the sums that he's talking about there, this book is already 2003, so all those figures will be significantly increased. It just gives you a good sort of overview of lots of the different uses of trust, which is one of the things that you'll look at right at the beginning of the module.
And to be a beneficiary of at least any sample of that, those billions of pounds worth of trust.
Yes, indeed, that would be nice, wouldn't it? And you mentioned before you're very interested in legal historians, and he mentions here Maitland. If we were asked, as you'll be aware, Maitland has written, if we were asked what is the greatest and most distinctive achievement performed by English men, now we might say English people, in the field of jurisprudence, I cannot think that we should have any better answer to give than this, namely the development from century to century of the trust idea. So I think that's really great as an introduction to how important the trust is to everyday life and to those with money, those without money.
Absolutely. It sits nicely with the commercial exposition that Professor Barr gave about the modern use in the sense of commerce as well. And as you rightly say, and we've already mentioned Maitland has this long history with Liverpool, on which point, before I forget, there's an excellent portrait of Professor Maitland in the Victoria Gallery and Museum, so check that out as part of your Trust's background research. Thanks very much. Obviously this is a secondary source that means a lot to you, other than the fact it's signed, but what Professor Hayton's written about. Are there any other secondary sources that you might want to highlight to the undergraduates that you have found interesting?
Well, you mentioned before about Tony Oakley taking over the Parker and Mellows book. But I don't know if you're aware that little book he wrote on constructive trusts, the Tony Oakley book on constructive trusts. I really liked that. Now, again, I haven't looked at it for a number of years, and I don't know what stage it's in now and how up to date it is. But there was, I used to find that really helpful in the context of constructive trusts, and there was some really good stuff in there on secret trusts if students want to have a look a bit beyond the syllabus and look at different areas of trusts as well.
I think I like you. I too think Hayton's writing is incredibly clear.
Yes.
Some of his work, you know, we've discussed enforcement of private purpose trust recently, and his pushing the boundary work on that in the context of commercial instruments as well, just phenomenally clear. Okay, excellent. So that's your first choice. What would be your second, either theme, secondary source, anything you'd like to bring up for the students?
I was going to talk about the maxims of equity. And again, it's something that you usually hear about at the beginning of your module on equity and trust, but it's certainly something that you should not forget about as you go through, a bit like the introduction that I read out previously. So a lot of it doesn't mean that much when you just hear it for the first time, but just as a hint to students, you should go back and look at the maxims again when you're looking at cases, because I think they're just a fantastic sort of summary of the whole way that equity works. I like to think of the maxims as sort of completely opposite to something like the Ten Commandments, because they weren't delivered on tablets of stone, because sometimes students say, well, what's the authority for the maxims of equity? Or someone will tell you there are 10 maxims of equity and they'll say it with authority. Someone else will say there are 11 or there are 12. It doesn't really matter, because they weren't laid down in a case as an authority. They are the principles that have been drawn out over the years to explain the way in which the workings of equity and trusts operate, the way in which the Court of Chancery initially, and now the courts when they're exercising equitable jurisdiction, work. Maxims that you should particularly look out for as students as you go through your course, the clean hands principle. So a professor who taught me always used to do that whenever he said clean hands. That wasn't David Parker, that was Tony Hudson, who was here. He'd always say clean hands. So a person who comes to equity must come with clean hands. And you'll come across that a lot, and you'll start to illustrate it through the case law. What else do I like? Equity looks on matters done which ought to be done. And a lot of these, they sort of go together, don't they? Equity imputes an intention to fulfil an obligation. Equity looks to intent rather than form. It's all this idea that we forget about all the red tape and the paperwork and the formalities. If you've said you're going to do something and then you do something else that can be interpreted as having fulfilled your initial obligation, then equity will regard you as having fulfilled your initial obligation. So if the common law requires certain formalities, deeds and things like that, equity will say, oh, don't worry about the deeds. And it would be unfair for you to go back on your word later by saying, oops, there wasn't a deed, when really all you're wanting to do is go back on your word when you said you'd make a transfer of shares or a house or whatever. So I really like that idea, and it's very much rooted in the whole idea of equity is fairness. And I've sometimes said to students over the years, if you had to sum up the maxims in sort of a sentence, how would you do that? And we quite often come round to the view that equity is fairness. If you look at all the different maxims, what I also like about the maxims is that you can usually use one and then possibly another, and they might sort of conflict with each other, because it's always discretionary, isn't it? So equity follows the law, and then you'll get yes, but not slavishly so. If equity always followed the law, there'd be no separate case law, no separate jurisdiction. So equity tries to follow the law. It doesn't create law in different areas to those that are governed by common law. It just adopts sometimes a different slant if that's going to lead to a fair result. Another thing about the maxims which is useful is that you'll come across them again in land law in terms of priority. So some of the maxims look a bit funny when you first read them from an equity and trust perspective, because they're dealing with how interests in land law take priority over other interests, but a lot of it will click together. So don't forget the maxims, but just bear in mind they're distilled from the cases, and you'll find cases that illustrate one or two of the maxims. For each maxim there will be cases where those principles have been used to come to a decision, but we don't have an authority for the maxims of equity. And I like that because it shows the flexibility and the discretionary nature of the subject.
Yes, excellent. Yeah, absolutely. I think you want to touch on Eves and Eves later on, maybe. So perhaps we'll relate that back to a maxim. Similarly, elsewhere on the Vital website, there is a 5-minute summary video on the maxims as well, which attempts to relate some of the maxims and others that Debra's mentioned to specific cases, which is important because of the question we're about to ask Debra, which is this. When using the maxims as an undergraduate, and you've already talked about secondary sources and the elegance of Hayton's writing and how that might be deployed, how do you think about deployment of maxims with assessed work? So how important are they in that sense?
If they are relevant, then they are important, aren't they? I'd always, if you're going to refer to a maxim, you need to make sure that you understand it properly and you have case law that backs it up. Because on its own, it's just a statement, isn't it? And you need to show that you've read the cases, you've seen where they come from. I usually, or quite often, I've referred to Snell's exposition of the maxims because it's quite useful. So Snell's equity, that's a good secondary source, although it's very weighty. But in terms of the maxims, I find that quite useful. So make sure, if the maxims are relevant or particular maxims are relevant, the clean hands principle might be relevant, or looking at the effect of delay in equity. Delay defeats equity. If you know you've got a claim to be made, you know about the limit, or you will know about the Limitation Act, where you must bring a claim at common law within a certain period of time, or your action becomes stale. Equity has the same notion, but it extends it. It makes it more fuzzy, doesn't it? So you could still be within the Limitation Act period, and yet equity might still say that it's unfair for you to be able to bring an action. And some of that overlaps, doesn't it, with things like estoppel? Because if I stand back knowing that I've got a claim, let's say you're spending money on a piece of land which I know full well is mine, I can't stand back and think, well, I'll wait till you've improved it and I'll wait till you've spent all that money on it and then I'll make my claim. So it might be an estoppel claim that prevents me from an estoppel defence, or it might be that equity says, delay defeats equity. But in terms, going back to your question, if you're going to use the maxims in a piece of coursework or in any other legal writing that you do, you must back it up with authority. So that would be referring to particular cases where the particular maxims have become relevant.
Yeah, excellent. So far then, to recap, Debra's given us the love of a secondary source that's highly influential, shows the huge influence of the trust in a pervasive sense across many different areas. And then the second point she's given us then is maxims and their deployment, both in the assessed sense, but also how we might think about how they help us push the boundaries of equitable thought. And she touched on fairness, perhaps was implicit when she talked about uncertainty and reining back from uncertainty with the deployment of some equitable ideas as well. Then perhaps it's that balance of thought that makes the subject makes the subject so very interesting. So there are 2 points, and we'll go into our third. Perhaps this is a nice segue, if you want to, into Eves and Eves.
I think it is, isn't it?
Would you like to tell us about why Eves and Eves has been important to you as a?
It's one of my cases or one of my Desert Island Disc cases, I guess, because it's one I remember very well from my student days. It had been decided, so 1975. It had already been decided when I was at university, and it's a case that. One of the judgments was given by Lord Denning. Students always like Lord Denning. We always have a little grin, don't we, when we think about Lord Denning. And this was a classic case for Lord Denning because it was one of the cases that you'll look at in the context of trusts of the family home. The idea that property can be in the name of one person, but so at law, you might be the owner. But equity might say, well, it's unfair for me, the other person who might have lived there, who might have contributed in indirect ways to the acquiring of that property and the improvements of that property. Equity might say it's unfair for you to keep that property outright for yourself. The other non-legal owner also has an interest in the property. If I have an interest which is recognised by equity, then it will have to be an equitable interest in the property. You are the legal owner. I am an owner in equity, together with probably yourself as well. The thing that connects those two will always be a trust. So whenever you have separation of legal and equitable ownership, there will always be a trust that connects them. But of course, it's not an express trust. So when you bought the property, you didn't declare that you held the property on trust for yourself and for your non-legal owning partner. But something happens, something which the courts think is only fair to say that another person has an interest in the property. And if you think about how that might come about, it's classic Lord Denning territory. We talk about Lord Denning liking little old ladies, poor young women, duped young girls, and poor Janet Eves. She was one of these girls.
I hope that when you were just saying that legal title, you weren't equating me to Stuart Eves, because that, as Deborah might now explain, you behaved a bit dodgily.
He wasn't a great specimen of the human race. The thing I always remember about this case, so basically you had a very young woman with an older man. He'd been married before. She'd actually been married before. They got together and they started to live in his house, and the question later arose as to whether she had an interest in the house. She'd done quite a lot of work on the house. According to Lord Denning, she did much more than many wives would do. Not quite sure what many wives are supposed to do, but she did a lot more than that. She'd done a lot of physical work on the property, breaking up concrete, carrying pieces to the skip. And I love the way the case goes into the detail, but the thing I love about it the most, the things I always remember from when I was a student, is the first line of Lord Denning's judgment. And you can tell he's really fallen for Janet Eves. He feels sorry for her straight away. He says, he starts his judgment, and he likes to tell a story. I will call her Janet, because she has had 4 surnames already. She was married for the first time at the age of 18, but that marriage only lasted about a year. Next, at the age of 19, she met a man, Stuart Eves. He was a married man. They couldn't marry, they started living together. She took his name, they had 2 children. After 4.5 years, the relationship broke down. The question now arises as to the ownership of the house that they lived in. He told her a lie. He said because she was under 21, he couldn't put the house in both their names, and but for her age, he would have put her name on the title deeds. Denning says this was an excuse. All along, he was determined that it was to be his house. And you get this picture, and as you're reading it through, you know the way it's going to end up. Then we learn that the thing I like about equity and trust is you learn about. So at one point he was going to marry her. After they got divorced, they'd agreed they were going to get married. Soon after, he changed his mind. He met another woman called Gloria. He met her when he got a job as a minicab driver. It's a little bit like a soap opera, isn't it? She got an order giving her custody of the children, Janet, and he was ordered to pay her maintenance. He didn't keep up the payments. As you say, he went back to the house. He locked up the 2 big rooms, leaving Janet and the children, 1 bedroom, the kitchen and the toilet. He took away the deep freeze and the stair carpet. I mean, how petty can you get?
But it's the children point that I always, why? It's just like, as you say, like human nature. And then, to wonder what extent the Lord Justices were influenced by that kind of...
Oh, for sure, for sure. She left. She moved in with an Alsatian dog. Yes,
I love it. Aggressive towards her.
I love it. Yes. So you could tell that this was a classic case for equity. So getting to the meat of it, Denning says, a few years ago, even equity would not have helped Janet. But things have altered. Equity is not past the age of childbearing. And it's always interesting that we look at equity as a feminine concept that can be pregnant and give birth to new concepts. And one of her latest progeny is a constructive trust. So this is a way of saying that although you are the legal owner, in good conscience and fairness, the property should be co-owned in equity by somebody else, in this case Janet. So bottom line, the court held that the house was to be held on trust for himself and her. And I just loved it because as a student you could really relate to the issues that she was going through. It was just like watching, you know, a soap opera or a kitchen sink drama. And it's not the only case like that, but I always remember that first line. I'll call her Janet. She's had 4 surnames already and she's 19 years old. So it gives you a little bit of a flavour of the type of woman that Janet was. She needed all the help that she could get, and she wasn't going to get it from the likes of people like Stuart, Eves, Stuart and Gloria, no. Well, I don't know what happened to Gloria, but I would imagine that Stuart probably moved on from Gloria.
Not a glorious ending.
So it's a great example of, you could see that Lord Denning would always like equity because it's flexible, it's discretionary. You could say, if you're going to be critical, it was the exact kind of concept that he would love, because you will appreciate that he never had much time for precedence and that kind of thing. So it was a classic way in which he could be flexible on the basis of justice and good conscience. So classic case.
And I think on that Lord Denning theme, Professor Barr touched on Lord Bridges' judgment in Lloyds Bank and Rossett, and
that comes later.
Exactly. Well, we can have a kind of there's a passage between the two, and also some of Denning's behaviour, which the House of Lords looked back on in the very sense that Debra's just examined. The idea that, was he too liberal with his deployment of the New Model Constructive Trust or not, or perhaps it was a good deployment and exemplifies exactly that which Debra said, the idea of the Constructive Trust being deployed to help people like Janet.
Since this case, we may have put a lot of guidelines around it. So, for example, the tests that were developed by Lord Bridge in Lloyds Bank and Rossett. But the reality is, a lot of what was established at this time, in the 1970s, has stood the test of time.
Absolutely. I think if one was to trace a timeline, a bit like we do with the idea of how grades fall on a bell curve, if one was to start with Lord Denning in Eves and Eves, but also Cook and Head, and then perhaps trace it through the severity of Lord Bridge, you might argue, and then back into Jones and Curnow, Secdown, etc. I think we're going back to this sort of idea.
For sure. Some judges don't like the fact that it seems so flexible and without principle. So what we've had in the meantime, before we got back to this flexible approach again, we've put conditions on, but then we've sort of falsely found ways of satisfying those conditions. One thing I like about Denning is he was pretty honest. He didn't make no bones about it. He didn't pretend to be applying principles or clutching at straws. He just said, she'd been tricked by this no good. And she deserved the support from the courts.
Yeah, absolutely. I think there's 2 points that arise from this that I'll just mention to the students briefly. One is that there's a real, although this is of course as good as the real Desert Island Disc with the Lord Denning. So if you go onto YouTube, put Lord Denning Desert Island Disc, and you can hear it. It's excellent. 50 minutes of the Lord Denning talking in his Wiltshire brewer as well. So his accent right there type thing. So go and listen to it. It's brilliant.
He's got a couple of little books as well, hasn't he, that are really interesting.
Although didn't he get into trouble when he retired because he was frankly racist in one of them, which caused a bit of a kerfuffle in about 1982, I think. But I'll put the citations up. We've got a really helpful chap who does the IT side of these things, Philip Walker, and he will help me put up some links to both this YouTube thing and the citations that Debra mentions in captions above the screen for you to look at. The other thing that I thought we could touch on is you've already mentioned the clarity of Professor Hayton in terms of reading. You've mentioned Lord Denning's prose as well. What would you say about that, and perhaps other writers in aid to the students when they're thinking about how to construct their sentences?
Short sentences, to the point, not too flowery, don't beat around the bush, say what you need to say it clearly, say it once, and that's what you get from, if they're not very long judgments. I mean, judgments have got longer, haven't they, over the years, and I'm not sure if they've got better for it.
Much harder to dilute into Tudor on charities or
Yeah.
Will Hunter on bankruptcy. Yeah, so
Certainly.
to filter in, yeah.
But no, I mean, you know, anybody could read this with a little bit of knowledge of what is, you know, a little bit of background knowledge and understand straight away what's going on and why he came to the decision that he did.
I think. Well, I think. I'm not sure if it's Professor Patterson who's shown that Denning apparently a lot of his judgments were extempore, which apparently explains why they sort of the style.
It's really helpful, though. I mean, I often advise students, and I do it myself. Break down your sentences, make them short, so there's nothing really clever about long, flowery, flowing sentences. You just lose the flow and you lose the nature, the understanding of the sentence. So make it as short and clear as you can. You know, and using flowery language doesn't help.
Yeah, no. So that is a brilliant introduction to Eves and Eves and some themes that make up an entire group of seminars and bleed actually into 2 whole seminars. So thanks very much, Deborah, for that excellent introduction. And as you say, on the kind of case themes point, I think, well, I was just thinking of Brown and Burdett, a case where the judgment, and I think perhaps later on you might be touching on Jones and Locke as well, you know, incredibly short judgments that are a real pleasure to read, and because of construction, but also brevity.
Well, let's face it, the first thing we do when we get something to read is look how long it is. The shorter it is, the bigger the smile on your face as you start to read it. So if it can be said briefly, then I'm all for that.
Yeah.
That's not to say, because what we often get in exam answers, for example, is not enough detail.
Yeah.
It does have to have the detail, it has to have the depth of analysis that is required, but not wrapped up in superfluous information that's not relevant, or repetition of facts, or giving back what you're told in the question, that kind of thing. It doesn't get you anything. It doesn't get you any marks.
Yeah.
It's annoying, and it's just taking up time, particularly in an examination or in any kind of assessment. You don't want to waste effort and time saying stuff, writing stuff that's not going to help you to give a good answer and improve your mark at the end of the day.
Absolutely. I think, well, we're very lucky, aren't we? Because I think our subjects, both equity and land, together, all about words, isn't it? It's fantastic, like playing with the words and you know, how they fit in. So
and to the point, they're not that flowery. I mean, land law particularly, you know, students don't have to write long answers, they need to write accurate, relevant answers.
Yeah. Well, excellent. It's really good meat for our thinking here for how we approach the subject. So, okay, we've had 3 then. I've already given a hint as to what the 4th one is. Your 4th area, Deborah?
I was going to talk about one particular case, Jones and Locke. I think it was because I was reminded about it because we were talking about Lord Cranworth the other week.
Yeah.
Is that you have
just acquired one of his signature.
You have his signature, yes.
Yeah.
So this is a case you'll come across when you look at constitution of trusts. That is how you completely form a trust. So as well as having to show that there was an intention to create a trust, and we know what the subject of the trust is and who the beneficiaries are supposed to be, that's the 3 certainties in relation to a trust. A trust must also be completely constituted. You'll come across the case of Milroy and Lord, which basically, there's always a bit of exception and manoeuvre, but basically, to create a trust, if I'm the settlor, I either transfer the trust property to somebody else to hold on trust for the benefit of the beneficiary, or I keep hold of my own property, but I declare that from now on, I don't hold it for myself, absolutely, but I hold it as a trustee. So it's either effective transfer or effective self-declaration. And Jones and Locke, it's a really old case. I had a look at it again today in preparation for this session. The hearing date was 21st of November 1865. And again, it's one of those short, pithy judgments. But I just like the facts of the case. So you're told that Robert Jones was an ironmonger. He had children by a first wife and 1 son, an infant about 9 months old, by a second wife. He went to Birmingham for a few days on business, and he returned. And on the day of the return, he was in his kitchen with his wife and his infant child and the child's nurse. And the nurse said, and you can just imagine somebody saying this, "You've come back from Birmingham and not brought baby anything." On which he said, "Well, I gave him a pair of boots, and now I will give him a handsome present." He went upstairs, brought down a piece of paper, which was a cheque for £900, and said, "Look you here, I give this to baby, it is for himself, and I'm going to put it away, and we'll give it to him later." So he writes a cheque in favour of baby, but then puts it back into his pocket. And again, it's another case that's always stuck with me. I don't know why. I always remember the facts, because I can just imagine it happening. Somebody goes away, business person goes away, comes back, and it's like, what did you bring for the kids? What did you bring for the kids? They're not satisfied that they've got a pair of boots, whatever they may have been. So to pacify, he writes, to pacify the nanny, he takes the cheque, he gives it to the child, gives it actually to the child, who's a baby. But then I guess frightened that the baby is going to tear up the cheque or whatever. Don't let him tear it up. And then he says, "Now, Lizzie, I'm going to put this away for my own son." And he locked it in an iron safe. I mean, £900 in 1865, that's some sum that we're talking about there. And as is often the case when cases come to court, that's something I'm really interested in, actually, how cases come to court. And this case came to court because shortly thereafter, Robert Jones, the ironmonger, died. And he hadn't properly given the gift to baby. And the question was whether that was, because it wasn't a valid transfer from himself to somebody else, so it wasn't a gift, it wasn't a gift on trust, so he hadn't given it to a trustee, he hadn't given it outright as a gift. The only other way in which there could be a trust was if there was an effective self-declaration from what happened. And the judge, Lord Cranworth, who was the Lord Chancellor at the time, couple of short paragraphs. He knew what answer he wanted to give. He wanted to say that the gift had been effectively completed, but he just couldn't, because he didn't think there was any way in which he could change the rules, which said that in that kind of situation the money had to actually be given to baby, or there had to have been a proper self-declaration, which there hadn't have been there. So Lord Cranworth, the Lord Chancellor at the time, gave the judgment in this case. He said it was a special case, but he regretted to say that he cannot bring himself to think that either on principle or on authority there'd been any gift or any valid declaration of trust. He came back to it at the end and he said, "I extremely regret this result, but it is obvious that by the act of God, i.e. the death of the father, this unfortunate child had been deprived of a provision which his father meant to make for him."
That is the bit that gets me every time, because that he meant to make for him. And you're thinking, hang on, isn't either I give this to baby symptomatic, or obviously of a gift, or of an attempt at self-declaration.
Indeed. Well, look at the maxims of equity. Equity imputes an intention to fulfil an obligation, and yet it didn't work here.
No.
Now, you might say, if Lord Denning had been deciding this a good 100 years later, maybe we would have had a different decision. I like the case because it's very vivid in terms of the facts. I can really relate to it. I remember it every time, and it just has that sad end that the child. The judge just said it was a symbolic,
loose conversation.
Yeah, a symbolic gift, and it wasn't meant to be. He said the testator would have been very much surprised if he'd been told that he'd parted with £900 and could no longer dispose of it himself. Not sure about that.
It's weird, isn't it?
Yes.
It's so perfectly explained as you have, absolutely. But I think you're right when you said that it was clear that Cranworth probably wanted to come to a different thing than he could have done, but couldn't because of the loose conversations pushed towards formality.
Yes, it's interesting that now, I said at the beginning, I hinted that Milroy and Lord talks about two different ways of completely constituting a trust, and yet quite recently we've suddenly discovered a third way as well. So it's never over, is it, in equity and trust?
Yeah, dual childbearing point again. Yeah, sort of. No, exactly, brilliant. Well, that's I'm afraid, Deborah, your 4 areas. You can't have any more in this recording. Maybe perhaps Dr. Picton will talk to you about 4 areas of charity. So, by way of conclusion, then, it is a version of Desert Island Discs, of course. So I can offer you 2 luxury items. Whilst you're thinking about those, I'll say you can have a copy of all of Hayton's work,
Yes.
and copies of Eves and Eves and Milroy and Jones and Locke. Your own copy of the last edition you worked on Tudor, on charities, but that's it. So they're your reading materials. What are your 2 items?
Okay, well, I guess in this modern day and age, I probably want to take one of these with me, an iPad. And some Wi-Fi,
okay, yeah,
if I'm allowed that. But if
yeah.
I'm on a desert island, that would absolutely suit me, because after 9 years in the Caribbean,
that
would be perfect.
Going back to your
indeed, back to my Caribbean roots.
So okay, well that I will permit that, mainly because if I don't, it would be unfair, because Professor Barr requested the same item. So there's a trend.
Great minds think alike. We've been working together way too long, I'm afraid.
Brilliant. Well, Maitland, Parker Mellows, Morris, now we have a proper link there as well that I was hitherto unaware of, so that's great. Thanks very much, Professor Morris. Thank you.
Thank you very much indeed.